Good afternoon and welcome to Ballard's SPAR webinar presentation, Are You Prepared for Ebola? A Guide for Employers. This is Shannon Farmer and I'm joined today with my colleagues Kelly Kindig and Meredith Swartz. We welcome your questions during and after the program, but we may be limited as far as time. Feel free to submit questions via the Q&A box on your screen or to email them to us directly after the program. Our email addresses are on the slides. If time allows, we'll answer questions during the webinar, and if not, we'll follow up with you after the program. We've circulated the slides in advance, and we'll also be sending slides along with a recording of the webinar as a follow-up. I think what we see in this first slide on what I find it to be a very entertaining cartoon here that ran in the Sacramento Bee is, as we've seen in many sediments, and we're going to talk about this, in a number of areas it appears that the fear that we've seen around Ebola is out of proportion to the public health threat that it actually poses. And we've seen that particularly in the response that has been issued by the Center for Disease Control, which is the federal agency that's responsible for this. And we're going to talk a little bit about how the CDC has responded versus how some state and local governments have responded, and also the public fear. So basic facts, and I think that this becomes very important when we talk about what the threat is and what the appropriate employer responses are in the workplace. This is a disease that is transmitted through contact with bodily fluids of infected persons or by butchering infected animals, so therefore contact with bodily fluids. Symptoms are typically going to appear 8 to 10 days after exposure, but the incubation period can span 2 to 21 days. And at 21 days, you may be hearing in a number of press reports and when there's discussions about quarantine and monitoring, talking about a 21-day period. One of the key things, though, as it relates to Ebola is that it is not transmitted by somebody who does not have symptoms or if somebody has recovered. So you have to be symptomatic in order to be able to infect somebody else. And that's very significant for employers when you're thinking about what the risk is in your workplace. We're going to talk a little bit later about the ability to, for example, exclude somebody from the workplace because of a fear of potentially having them infect other people and a direct threat analysis, but keep that in mind, that if somebody is not symptomatic, then they are not able to transmit the disease. In the United States, we have hundreds of people who've been tested or are being monitored. Originally, the majority of these were characterized as possible contacts by the CDC after one of the 2 nurses in Dallas who became infected flew on a commercial aircraft, and we are getting to or have just finished the 21-day monitoring period for them. However, what we do see is in a number of areas, both here in Philadelphia and in most cities and states, there are monitoring going on of people because they've traveled, things like that. Not quarantine, but monitoring by the government. What we have seen is a number of states that have announced quarantines that exceed the guidelines that the Federal Centers for Disease Control have deemed appropriate. Local examples in Philadelphia would be New York and New Jersey, and there are several other states as well. Just a cartoon that, again, showing this idea that people are expressing a fear of this virus. So on the federal government side, what we've seen is CDC guidelines being issued in mid-October, specific guidance for healthcare workers on treating Ebola patients, and there's very specific guidance now about making sure that the proper protective equipment is being used, including using a buddy system to make sure that all of the protective gear is being used properly and fully, and there's no inadvertent infections. Obviously a ramped up concern after there were the 2 nurses in Dallas who became infected after having treated an infected patient. There's also been guidance on this monitoring and movement of Ebola patients, again, stemming from the treatment of the patient in Dallas. But really here with the CDC guidelines, mostly the specific stuff being limited to the healthcare industry. There's also an Ebola czar who was appointed to oversee health security in the U.S., rapid response teams to help move in and help local officials in the areas. And then significantly, and I think that this plays into what employers should be thinking about, is there's now airport screenings that are going in. So the airports that see the vast majority of people who are traveling back from West Africa now have a screening program of passengers. And then what's happening is when people are screened, local health officials are being notified so that these folks can continue to be monitored. Not quarantined in most cases, but just monitored by local health officials. And that's generally going to be a phone call, checking in with them, asking them to monitor their own temperatures and report if they start to develop a fever. Fever is one of the early signs of Ebola and obviously one of the easiest to monitor for. If you're checking your temperature every day, you suddenly have a fever. So that may be going on. Employers may not even know necessarily that employees are being screened, but that is something that may be going on if you have somebody in your workforce who has traveled back from West Africa. On the states, what we've seen is a ramped up, I think it's fair to say, response in many areas above and beyond what the federal government is doing. So there are mandatory quarantines that have been imposed in at least 6 states, and we've also seen states looking at things on a case-by-case basis. You might have seen Maine, for example. The governor's office went into court last week to try and get an injunction to have a nurse who was originally quarantined in New Jersey, who was then transported to Maine, which is where she lived. When she was treating Ebola patients in West Africa. When she came back, New Jersey's health officials picked her up and quarantined her. After she threatened to sue, they agreed to release her and let her return to Maine. When she got to Maine, they asked her to remain in a voluntary quarantine, I'll put voluntary in quotes there, in her home. She has resisted some of the terms of that, and after she was sort of famously seen out on a bike ride with her fiance, with police trailing her, the state went to court to try and get an injunction, and that was denied by the court, who said she doesn't have symptoms, she's not a public health threat. Now, that's somebody who is monitoring her symptom, monitoring her temperature, monitoring her symptoms, but would not accept the terms of quarantine of having to physically stay in her home. So we see in other states there's been mandatory monitoring for people who've been potentially exposed to the Ebola virus. So for example, in Pennsylvania, there were people who flew on the flight with that Dallas nurse were being monitored by the state, and that took the form of people reporting their own temperature into the state health department. We're not being confined to their homes. We're not having their movements restricted, but really just the monitoring. We've also seen some scattered instances where schools were being closed in Ohio and Texas, and that relates again to that nurse who flew because she flew from Texas to Ohio. There was a middle school principal in Mississippi who agreed to stay home after traveling to Zambia, which is nowhere near the outbreak, and I think that relates to some of the fears and assumptions that relate to this epidemic that Kelly is going to talk about. There was this teacher in Maine who was placed on a paid leave after she went to Dallas simply because she had been in Dallas, where this nurse, and students were told to stay home in certain areas of Connecticut and Oklahoma, again, due to fear rather than a specific exposure threat. And so we've seen some responses that appear to be out of proportion to the actual exposure threats. So for employers, there are a number of areas where issues can arise. One, and because the epidemic the Ebola epidemic is really localized in West Africa. We can see issues related to national origin discrimination when dealing with both employee fears, if that's an issue in your workplace, and also public fears. Issues related to leave, if people are quarantined or voluntarily remaining at home during a potential incubation period, or if they do become ill. The issue of medical inquiries and examinations under the ADA. So what can you ask if you believe that an employee might have been in a high-risk area, for example? And then the employer's duty to protect employees from workplace hazards under OSHA. In this area, we see little specific guidance for employers because we have not seen guidelines by the EEOC or the CDC for employers, other than there's the guidance that we previously discussed about the healthcare industry. And there is a new OSHA guidance that addresses the protection of workers in certain industries, but really focusing on that physical protection and not addressing the general employer concerns. Healthcare is obviously a sector where there's a risk of exposure that is going to be higher. Other areas that have been identified, the airline industry, because of flight crews and also people who may be transporting or cleaning aircraft. Secondary health services employees, so laboratory technicians who are going to be exposed to blood or samples. Environmental services and waste management who have to clean up. Mortuary workers who have to handle the dead and deal with those bodily fluid. First responders, so paramedics, police officers who may be arriving on scene where there may be a potential exposure. Another area where there's been concern expressed is hospitality workers. So in hotels, in restaurants, concerns about exposure to bodily fluids of people who may be ill but may not know that. And also another area that's been identified is shipping and warehouse workers if they have contact with goods or animals that are arriving from affected areas, particularly without knowing it. And the issue, I think, with both hospitality and the shipping warehousing workers is these are not industries where people necessarily think about wearing protective equipment, PPE. You don't typically see, your waiter at a restaurant wearing gloves and a face mask, and people may have a very negative visceral reaction if they were to see that. So that creates some different issues for employers than there would be, for example, in the healthcare industry where people are prepared and are wearing that kind of equipment. And with that, I'm going to turn it over to Kelly to talk about national origin issues.
Thanks, Shannon. So we'll focus a little bit now on national origin discrimination, and I think this is probably an area that may be a big trap for the unwary for many employers with respect to Ebola. And the cartoon that we had on the previous slide can maybe highlight some of the prejudice that might arise in this situation. Because the Ebola outbreak is localized to a particular geographic area, the possibility of discrimination is more likely than with the other types of pandemics or epidemics that we've seen in the recent past, like H1N1. We're also seeing, as Shannon has mentioned, a greater level of alarm in the public, in the media, and unfortunately among some government officials. And that could contribute to unreasonable fears among employees. It can fuel prejudice in the workplace that might not have been apparent before. Employers need to be sensitive to these discrimination concerns and take a step back from the fear and concerns surrounding Ebola and ensure that you're treating all of your employees similarly and applying your policies even-handedly and making decisions based on business needs and the actual facts in front of you and not on unfounded fears or hysteria. Employers also need to be aware of the potential for harassment of employees in the workplace. You could have employees who either are actually from affected areas or simply perceived to be from affected areas. We've already seen stories on the news about children in schools who are being bullied at school about Ebola, and it's really, from our perspective, only a matter of time before stories start coming out about this happening in the workplace as well. We also think that the stage is currently set for one particular scenario with respect to national origin discrimination to arise. the issue of customers expressing a preference not to have contact with an employee based on the customer's perception or knowledge that the employee is of West African origin or descent. For example, a patient in a hospital might ask for a different nurse if he or she believes that the nurse currently providing care hails from West Africa. Could have parents at a school request that a teacher be removed from the classroom based on similar fears or prejudice. And we saw these types of scenarios arise in the wake of the 9/11 terrorist attacks, based on stereotypes about Muslims or individuals who are perceived to be of Middle Eastern descent. The EEOC responded to those cases by issuing guidance on the issue of customer preference. And in that guidance, the EEOC has made abundantly clear that if an employer takes action in response to such requests, it's a form of unlawful national origin discrimination in and of itself, and customer preference is not going to be a valid defense to a national origin discrimination claim. So employers need to be sensitive to these potential scenarios arising in the workplace, and again, ensure that all policies are applied even-handedly among employees. I'll turn it back to Shannon now to talk about leave issues and the quarantines associated with Ebola.
And just before I do, one additional comment on this issue of customer preference. Sometimes we get asked, well, if, for example, a nurse is reassigned from one patient to another, what does it matter if they didn't lose pay, right? They're still working, they're still assigned. But that is not the view that the EEOC has taken, because the EEOC has taken the view, and there are some courts have as well, that there is damage through basically this stigmatization of having been singled out. And also, if employees are then being removed from assignments, it could impact, maybe not on that particular day, but it could impact scheduling of future shifts, overtime opportunities, and potentially opportunities for skills development and advancement. So it's not just enough to say, well, the person was still working. And it's obviously a very difficult issue for employers. It comes up in a variety of areas. We've seen it, for example, in addition to healthcare, we've seen it in the past in a lot of issues related to retail employers, for example. People saying they didn't want to be waited on by a particular person. You can see it in the hospitality industry, in really a variety of industries that deal with the public. And, while this puts employers in a difficult position, that is something that employers have to deal with. And if there are specific questions, that's a good opportunity to consult legal counsel and talk through those issues if you believe that that's coming up in the workplace. The next area that I want to talk about is that of leave and quarantine. With these issues coming up on the state and federal level, and more so on the state level, of quarantines and leave and voluntary or not so voluntary monitoring, it raises questions about the status of these employees during the leave. And I think that you can see reflected in this cartoon this, question of, we have Lady Liberty here sort of marking off the days while she's locked in a room, and I think intended to be the contrast between what had traditionally been seen as sort of the welcoming nature of America. Employees who are quarantined for their own exposure or that of a family member may seek leave under the FMLA, the Federal Family and Medical Leave Act, or corresponding state laws. Now, whether they are eligible for that leave is likely to depend on both the circumstances of the quarantine as well as the general eligibility rules for the FMLA. So we're going to talk about both of those briefly. The FMLA is the federal law that gives eligible employees up to 12 weeks of unpaid leave in each leave year for their own serious health condition and the serious health condition of a family member. There are some other bases for FMLA leave that would not be related to this circumstance, so we're not going to talk about them. This leave is unpaid, but employees are permitted and can be required to use any available paid leave benefits. In order to be eligible for FMLA leave, the employees must have worked for the employer for at least 12 months, have actually worked at least 1,250 hours in the preceding 12 months, and by actually worked, we mean performed work. Paid leave time does not count. Time spent on that was spent on military service that otherwise would have been worked does. Work at a location with at least 50 employees within a 75-mile radius. So the FMLA is only going to be applicable, first of all, to an employer who has at least 50 employees, but then even more than that, they have to be at a location, the employee themselves has to be at a location where there are at least 50 employees within a 75-mile radius. If you're an employer that has scattered employees, for example, employees that work out of their home, then you should talk to counsel about how those employees are being counted and where they're being counted for purposes of that threshold. If there are questions, the general rule is that you don't count their home location as their work location under the FMLA, regardless of where you might count it for purposes of taxation, but instead it's the location from which they get their assignment. So if that's from a central office location, that's going to be their work location for the FMLA. If they get all their direction from a supervisor, then it's going to be their supervisor's location. Whether that's an office, it could also be, if the supervisor works remotely, it could even potentially be the supervisor's home, which leads to a somewhat ironic situation where the employee's work location may be their supervisor's home, but the supervisor's location would in fact be some other location because your home cannot be your work location under the FMLA in most circumstances. So if there's questions there, that's something that you want to consult counsel about or look at more closely. And the final eligibility criteria, you actually have to have leave time available. So you have that 12 weeks. If that time has already been exhausted, then they're not going to be eligible for FMLA leave as it arises in this circumstance. So if an employee is eligible for FMLA leave, then the employer must continue health benefits while the employee is on leave on the same terms as if the employee was at work. They must be returned to the same or equivalent position with equivalent pay and benefits and responsibilities following the leave. So this is the question of, do you have to hold the employee's position open? And you can't take adverse action against the employee as a result of the leave. So how do you determine if an employee who would otherwise be eligible is eligible for FMLA as a result of a quarantine either of the employee or a family member? So as I previously covered, the FMLA provides leave for an employee's own serious health condition, that of a family member. What's a serious health condition? It's an illness, injury, impairment, or physical or mental condition that renders an employee unable to perform at least one job function and that involves either inpatient care, incapacity due to pregnancy or for prenatal care, obviously not applicable in what we're talking about, incapacity because of a long-term condition, again, not applicable, multiple treatments and recovery therefrom by a healthcare provider, we're going to talk more about that, and a chronic serious health condition, not the situation. So in the situation where we're talking about potential Ebola, we're really talking about either meeting the definition under inpatient care or multiple treatments and recovery, and keep that in mind as we continue to talk about the FMLA requirements. The next requirement that plays into this is a medical certification. So under the FMLA, when an employer becomes aware of an employee's possible need for leave, the employer has the obligation to inquire further to determine if the leave is in fact FMLA qualifying. One of the ways that the employer can do that is by requesting a medical certification from the employees, or if it's for a family member, the family member's doctor, to determine whether the condition is FMLA qualifying, whether intermittent leave is medically necessary, if that's in play, the probable duration of the leave schedule, duration and frequency of intermittent leave, and the probable number of duration and treatments, if in fact that's applicable, or the period for recovery. But primarily trying to determine whether this is FMLA qualifying and also being able to plan, what to expect in terms of its duration. As we apply these principles to Ebola, we can look at two different sets of scenarios. Those of people who are actually infected with the disease and those who are not but have been potentially exposed and under quarantine. If you have somebody who has contracted Ebola, there is little question that that person would have a serious health condition under the FMLA and be entitled to leave if otherwise eligible. And that would be true if the employee's parent, spouse, or child contracts Ebola as well, because those are the qualifying categories of family members under the FMLA for whom somebody can take leave. But what about somebody who's going through either a mandatory or voluntary quarantine or monitoring? The serious health condition, as we talked about, includes situations where an employee must be absent from work to receive treatment. And that treatment includes examinations to determine if a serious health condition exists. So if somebody is under the care of a healthcare provider and there's ongoing treatment and the regulations say here we're talking at least 2 in-person visits to a healthcare provider, that would be a continuing course of treatment. But in many of the situations that we're talking about here with these quarantines, that is simply not the case. People are not necessarily going to their doctors and getting treatment, and certainly not multiple trips. What we have in many of these situations is people who are being asked by state health or local health officials to take their own temperatures and simply report their temperatures over the phone. And it appears unlikely, in the absence of a change of the regulations or guidance from the Department of Labor showing sufficient legal authority, that that kind of a situation would qualify as a serious health condition under the FMLA. These are not people who are physically unable to work as a result of these conditions. We're talking about people who are healthy, who are not experiencing signs and symptoms of a disease, but are being asked by health officials to simply report their temperature. And I think asking for it, if you were to ask for a medical certification to support that, it would demonstrate the issue, because who would complete that medical certification? This is not leave that is being required by the employee's doctor. This is leave that is being requested or required by a state health official based on a potential threat, not based on a medical condition that the employee has or any physical or mental inability to do the work. So while there may be circumstances specific to the employee's response to this that may qualify for FMLA, I don't believe that the quarantine order in and of itself would make the employee eligible for FMLA. Now, what's the significance of that? Does that mean that somebody's quarantined and as an employer you're going to go right out and terminate that person? No, of course not. What it means, though, is that employers are not required to continue health benefits. Employers are not required to hold the position open and to return the employee to the same position. In many instances, perhaps in most, given the relatively short period of time that we're talking about, 21 days, in fact, employers are going to continue health benefits, and they are going to continue to hold those positions and to return the employees to work under those circumstances. It's very difficult to imagine, for example, a hospital or health system giving a doctor or a nurse time off to go and treat patients in West Africa and then terminating the person when they return because they were subject to a state quarantine. I think that's very unlikely to happen, and obviously there's really questions about what the publicity would be were any hospital or health system to do that. But that's a separate issue than what would be required by the FMLA. On the other hand, if we move outside of that arena and we're talking about employees who don't necessarily have benefits, who don't necessarily work regular schedules, types of shift employees, you can certainly imagine a circumstance where there would be employers who are filling those shifts and would be bringing people in, and then the question is, what happens then? Do they get their shifts back? Is it necessarily the same schedule? So some of the very specific rules that may apply to the FMLA would not necessarily. The FMLA sets a floor. You can have employer policies that are more generous, and many employers, in fact, provide for medical leaves of absence that have far less strict requirements than the FMLA. In addition, you can have state laws that provide leave that could be applicable because they have different definitions. In addition, there are a minority of state laws, New Jersey being one of them, that specifically provide job restoration rights for employees who miss work as a result of a government-imposed quarantine. New Jersey has a specific provision that is very similar to a restoration after military leave. After the end of the quarantine, employees have to apply for their job back within a certain number of days, and then they have to be reinstated, benefits, all of those things. But that is a small minority of states. So this is an area where there may be some flexibility for employers, but obviously before an employer were to make the determination that it was going to terminate an employee as a result of a government-imposed quarantine, you want to think through all of the implications of that, including singling employees out. Is there a discrimination because you've granted leave beyond what the FMLA requires to other employees of different races or national origins under different circumstances? You want to think about the publicity aspect of it and consider any other implications that there might be. And with that, I'm going to turn this over to Meredith to talk about medical inquiries and the Americans with Disabilities Act.
Great, thank you. And as we've previously discussed, it is natural for many employers and employees to be concerned about potential exposure to Ebola, particularly when colleagues return from travels in West Africa. Employers should educate themselves about the Ebola virus, including its methods of transmission and the signs and symptoms of infection. As this slide shows, right now, Americans are significantly more likely to die as a result of the flu or pneumonia than Ebola. Over the next few slides, we will discuss why it is important for employers to engage employees cautiously in order to avoid potential liability under the ADA. Briefly, the ADA imposes certain obligations on covered entities, which includes employers with 15 or more employees, employment agencies, labor organizations, or joint labor management committees. The ADA prohibits an employer from discriminating against a qualified individual on the basis of disability, and that also includes discrimination in the form of regarding an individual as disabled. The ADA also requires employers to make reasonable accommodations to the known physical or mental disabilities of an otherwise qualified individual, unless to do so would impose an undue burden on the employer or the employee would pose a direct threat to the employee or others. The ADA also limits an employer's ability to make medical inquiries or conduct medical examinations, which we'll address in a bit more detail in the next slides. Employers must be sure to keep all information, including information obtained about Ebola, that they receive through disability-related inquiries or medical examinations confidential. The EEOC has made clear that information regarding the medical condition or history of an employee must be collected and maintained on separate forms and in separate medical files and treated as a confidential medical record. This isn't the first time that there's been some concern about an epidemic and or pandemic in the country. And previously in 2009, the EEOC released a pandemic preparedness guidance addressing the 2009 H1N1 global pandemic. And importantly, while this information might be helpful and useful to certain employers and is available on the EEOC's website, the employer should use caution and not rely solely upon this guidance when responding to an issue related to Ebola. And the reason is that there are significant differences between the 2009 H1N1 global pandemic and the present Ebola epidemic in West Africa. As of right now, and as the CDC has made clear, there is little reason to anticipate that there will be widespread transmission of Ebola in the United States and thereby not likely to become a global pandemic. Nevertheless, employers can resort to the pandemic preparedness guidance if they want some information on how the EEOC may consider Ebola in the event that they elevate the severity of the illness. So the EEOC guidance on pandemic preparedness discusses what types of inquiries employers may make, and disability-related inquiries and medical exams are prohibited unless they are job-related and are consistent with a business necessity. This requirement is met when an employer has a reasonable belief based on objective evidence that an employee's ability to perform the essential job functions will be impaired by a medical condition or an employee will pose a direct threat due to a medical condition. Here, the employer's options really hinge on the direct threat analysis. And under the ADA, an employer may not send an employee home because of a disability unless the employee poses a direct threat to the health and safety of others. The EEOC views a direct threat as a significant risk of substantial harm to the health and safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. The determination as to whether or not a direct threat exists cannot be based on fears, misconceptions, or stereotypes, or the employer's assumptions or suspicions about an employee's exposure to Ebola. So whether an employee poses a direct threat or not must be based on reasonable medical judgment that relies on the most current medical knowledge and best available objective evidence. An assessment by the CDC that Ebola is a direct threat would provide justification for disability-related inquiries and medical examinations. However, the CDC has not made any such determination to date. The pandemic preparedness guidance is helpful in that it does direct employers to stay up to date on CDC and other public health guidance as it becomes available. So what are some potential issues that employers may find themselves facing when it comes to Ebola? The first question that has been a common question so far is, what can the employer ask of an employee who travels to a high-risk area? And the first thing I think it is important to note is that people who are currently returning from Ebola-affected areas are being monitored by state and local health officials. So as Shannon mentioned, it is not as though these individuals are returning to the United States and are not being monitored by the government. Nevertheless, employers may require employees to report to the company any diagnosis of a contagious illness without requiring the employee to specifically identify the diagnosis or illness. Employers may also brief their employees on the symptoms and signs of Ebola and ask traveling employees to be alert to any such symptoms developed within 21 days after the employee's return. If an employee actually develops such symptoms, then depending on the specific facts and circumstances, the employer may be able to conduct a medical examination and or determine whether or not the employee poses a direct threat to the workplace. Another question is, how can employers handle fears and concerns of coworkers and the public? And I think it's incredibly important that coworker concerns are handled carefully. Generally, the law is somewhat insensitive about employers concerned about coworkers, as Kelly and Shannon mentioned with the customer preference issues that are related to potential national origin discrimination. The best response is to share information from the CDC with employees and assure them that the situation is being monitored and that you're paying attention to the CDC and state and local health official guidance. Educating employees now may help them avoid overreacting to employees who may be of a particular national origin or who have traveled to a particular region. Another question is, what else can you be doing to address these concerns? And in addition to educating yourself about Ebola, it is important to put in place a plan that will prepare you to deal with any potential Ebola exposure issues. It's important to stay abreast of any guidance issued by the EEOC and or CDC, and also to be prepared to cooperate with health authorities as they work to identify and isolate persons who may have been exposed to the virus. Employers may also implement infection control processes, such as regular hand washing procedures, proper tissue usage, sneezing etiquette, and other things along the lines that are similar to what you may already implement during flu season. And one of the last concerns or questions is, what can an employer do in light of a potential exposure? And If there has been an actual exposure to the virus, it is important to contact the local health department and the CDC. And clearly, if an individual actually has the Ebola virus in your workplace, the direct threat requirement would be established, and you could exclude that employee from returning to the workplace until he or she recovered. So moving on to medical examinations. Some employers have had a somewhat knee-jerk reaction and been inclined to start taking or wanting to take employees' temperatures. Healthcare workers who have been potentially exposed to the virus have been taking their temperature twice a day because fever is the first symptom of, or one of the first symptoms of the Ebola virus. It's important to remember that the EEOC does consider taking an employee's temperature to be a medical examination, which is typically prohibited unless the employer determines it is job-related and is a business necessity. To the direct threat determination, which could justify a medical examination, must be based on particular facts, not fears or assumptions. Because there are no current international travel restrictions in place, and because the Ebola virus has a very low risk of transmission, requiring a medical examination or requiring an employee to have their temperature taken for someone who's returning from travel to West Africa alone would likely not be consistent with business necessity and would not be able to be, an employer would run the risk of running afoul of the ADA in the event that they ask an employee to take his or her temperature. And it's important to note that you can't use a medical examination to establish a direct threat. The direct threat has to be present prior to being able to perform any medical examination or evaluation. Employers can brief their employees on the symptoms and signs of Ebola and ask the traveling employees to be alert to any such symptoms. If the Ebola reaches the pandemic level as assessed by the CDC or local public health authorities, there may come a time when employers would be permitted to take employees' temperatures since the direct threat would be established by any sort of guidance or publication from the CDC. And just to remember, note, I think it is pretty self-explanatory that medical exams for anyone who is merely from any of the West African countries that have been affected by Ebola could run afoul of Title VII, as Kelly previously mentioned. Some other considerations that employers might be looking into are whether or not a quarantine is necessary for an employee who has potentially been exposed, or whether an employee should be forced to take a 21-day mandatory leave of absence during the incubation period. And as we mentioned, absent any symptoms or other evidence of exposure, employers run the risk of disability discrimination for regarding an employee as disabled if they were to require such a mandatory leave of absence or mandatory quarantine. Again, it's important for employers to keep abreast of any developments by the CDC, and if in fact the CDC ultimately recommends that individuals who visit certain countries alone must be quarantined for a certain period of time upon returning to the United States, at that point in time an employer may be able to implement similar restrictions in the workplace. However, the CDC has not yet done so. Paying an employee who is placed on a leave of absence in the event that employee voluntarily decides to go out on a leave of absence or other circumstances require the employee to go out on a leave of absence does not affect whether or not there's been a violation under the ADA, but it may ultimately reduce the risk that employee will file a charge. And with that, I'm going to turn it over to Kelly, who's going to go over some additional considerations under OSHA and the NLRA.
So as we move on to the topic of safety, sorry about that. As we move on to the topic of safety, pause for a second on this political cartoon that we have here. We have two intrepid CDC workers dressed to the nines in their personal protective equipment, and one is asking, you know, is it just me, or does this look like the beginning of every zombie movie ever? And, you know, we have been hearing jokes in the media analogizing the Ebola outbreak to the zombie apocalypse and this sort of, a tribute to how the public has been responding to this outbreak. And this cartoon jokes about the level of protective measures that are being taken in response to Ebola. And we've been talking a lot today about what not to do in response to Ebola, but this is really one area where employers should be actively taking precautions to ensure employee safety. The Federal Occupational Safety and Health Act requires employers to maintain a safe working environment for employees, which does include providing the necessary equipment and gear to protect employees from exposure to diseases like Ebola. OSHA has issued guidance, which Shannon mentioned earlier. It's available on their website, and we have a link here that details employers' guidance with respect to employee safety and Ebola. The guidance does provide a very limited amount of general information on precautions and safety procedures for workers, things like wearing gloves, proper hand washing techniques, and the use of personal protective equipment. The guidance also identifies specific industries with a heightened risk of Ebola exposure, including, not surprisingly, the healthcare and airline industries, but also some of the industries that Shannon was talking about earlier, like mortuary workers, lab workers, and also first responders. The CDC also has been regularly issuing and updating guidance to healthcare facilities with respect to best practices for employee safety in that industry. We won't discuss this in great detail, but employers also could have situations where employees refuse to assist a customer because of fears about the customer or client having Ebola or having been exposed to Ebola. Those sorts of situations can raise the same safety issues that we're talking about and also some of the discrimination issues that we talked about earlier. OSHA also prohibits retaliation against employees who report safety concerns, which leads us into our final point for today, ensuring compliance with federal labor laws. Many of the industries that we've been talking about today, like healthcare, hospitality, airlines, et cetera, are heavily unionized. Employers may be subject to more stringent restrictions or protections offered by collective bargaining agreements regarding issues like sick leave, safety procedures, or providing personal protective equipment. We've already seen increasing activity by unions to address Ebola and workplace safety issues, from information requests about the employer's preparedness plans to requests for the employer to develop, modify, or discuss preparedness plans. We'll also touch a little bit now on about employee complaints. So when employees have complaints in the workplace about safety, that could fall under the National Labor Relations Act. Employees reporting a group concern about their safety in the workplace or about an employer's safety policies or procedures, or requesting additional safety precautions or protective equipment could constitute protected concerted activity under federal law and under the NLRA. Even a single employee raising a concern could be engaged in protected activity, both under the NLRA and under OSHA, by reporting those concerns, especially when the goal is group protection. And you can have employees reporting these concerns in a non-unionized workplace, which can also be protected activity under federal law, even in the absence of a union. And again, we've talked a lot today about the level of public alarm over Ebola, so many employers are worried about getting unreasonable requests or reports about safety. In those instances, employers need to balance employees' concerns with the level of risk based on the particular facts of the situation. And as we've been saying throughout the presentation today, employers need to be sensitive to all of these potential issues to ensure that they're ready to address them as they arise.
Thank you. We have a few minutes. If anybody has questions, please feel free to send them in through the Q&A. One of the challenges that I think that we find for employers is doing just what Kelly mentioned, balancing that risk of the fear that is out there with what the real threat is. And part of the way that employers can do that is through education. And this can arise in a lot of different ways. So, for example, Kelly mentioned that collective bargaining agreements can provide additional protections to what's under state law. It is not uncommon for there to be collective bargaining agreements for example, that specify that employees are not required to come to work in a situation that they believe is dangerous. So there are collective bargains that will say they don't have to work under unsafe conditions, and if it's a dangerous condition, they can refuse to work. And the question is, how does that apply to a situation where an employee may have a fear that there's an exposure to Ebola? And this is really going to be, in most instances, a fact-specific situation where you would look at that under your collective bargaining agreement, what the circumstances are of the situation. So, for example, if it's a hospital and employees are saying that they believe having to change people's sheets or clean their bathrooms exposes them to an unsafe condition because any member of the public who comes to that hotel could have been exposed to Ebola or could have Ebola, then that is a situation that most likely, no arbitrator, no tribunal would find that that would be an unreasonable exposure to work, because while there is some, obvious risk of exposure, it's very small, and it's not really different in kind than a situation, for example, where, you could have anybody who comes through that hotel could have the flu, could have a cold. There is some amount of exposure to potential germs that exist not only in life generally, but in that kind of an industry. So that's not an unusually dangerous condition. And in that circumstance, under OSHA, basic protective equipment would be what employers would normally provide. If you're cleaning the bathroom, there's going to be gloves, things like that. But we are seeing in it, in the hospitality industry, and as it relates both to hospitals and restaurant workers, employee advocates raising questions about, the unsafe working conditions. As I said earlier, this isn't an industry where we've typically seen a lot of protective equipment. We don't normally see waiters or busboys coming through restaurants wearing protective gear, and I think we can all imagine what that would be like if, in fact, your waiter showed up wearing the full hazard suit as displayed in the slide. That may not give a sense of security to those people who are there having dinner. So there's a balance that's there, and if there were a reason that there was a specific threat, if the CDC were to determine that that kind of exposure, for example, or state health officials, then that might be necessary. But just the general possibility that someone could be sick, really not very different than the fact that people go to restaurants with colds. People could have all sorts of germs at different times, and that goes to trying to really balance the fear with the threat and making a reasoned response and really being guided in many of these circumstances by the CDC. If you look at the EEOC guidance from the H1N1 pandemic in 2009, there are a number of areas where it talks about, okay, here's what you can do right now, but by the way, if the CDC determines that this rises to the level, then yes, you can do additional things. So really being guided by public health officials. I think it's very difficult for an employer without a very specific set of facts to make the determination that somebody is a direct threat in the workplace in a situation where the CDC and public health officials have determined that it is safe for this person to be at work. We have a question, what about a blanket work from home process for 21 days for employees after return from one of the affected countries in West Africa? And that is something that a number of employers, I think, have been interested in, concerned about. And, the ability to do that is going to depend on a few things. First, are you comfortable that you're not discriminating on the basis of national origin because you are requiring employees only who come from certain areas? So that would be the first concern. If it's limited to only employees who are traveling from West Africa. Two, if it's required, can you really determine that these people are a direct threat? As I said before, I think that there's a concern that that's going to be running afoul, at least as the current CDC guidance and state rules. Very hard to establish a direct threat when they are not being subject to quarantine by state and local officials. However, that doesn't mean that you can't, in a non-punitive way, encourage employees, if it works, to allow people to work from home as an infection control strategy during a pandemic. So this is something that the CDC, that the EEOC in their 2009 pandemic preparedness specifically endorsed as an option as an infection control, but not limited to employees coming from a particular area, but really specifically just to say, hey, the flu is out there. If you can let employees work from home, if people aren't together, there's less of a risk in the workforce. So I think that allowing employees to work from home as an infection control strategy anytime that we're talking about an epidemic or a pandemic, if it's voluntary, is one thing, but forcing it only on employees on a certain national origin when the public health officials and the CDC have not made that determination leaves you open to certain risks. Another question, what are our thoughts about using the CDC algorithm for risk in terms of determining the need for the 21-day leave? That's certainly something that's available as an option to try and make that determination. Question may be, as an employer, what access you have to the information that you would need to do that without making a prohibited medical inquiry. There's a little bit of a chicken and an egg issue here because you typically can't make the medical inquiry to determine, there's got to be a particularized basis to make the medical inquiry. So you may not have all the facts, the ability to do that, but again, just the fact that somebody has traveled from an area typically is not going to be enough. So another question, what questions can the employer ask of an employee who travels to a high-risk area? And Meredith is going to take that one.
Right. So this is an interesting question, and a lot of what can be asked is going to depend on the specific facts and circumstances. And although the 2009 EEOC guidance does provide some assistance for employers looking to ask questions of employees. For example, it allows an employer to ask employees whether or not they are suffering from certain types of symptoms. That guidance it's dependent upon the pandemic being already declared. And right now, we are not there yet. So I think an employer should be very cautious before performing any sorts of medical inquiries of employees who are returning from high-risk areas. Again, informing the employee of certain Ebola-type symptoms and asking that the employee be alert to whether or not they've developed any symptoms upon their return can be of particular assistance, and in some cases that may result in the employee actually coming to the employer if in fact the employee does identify that they are coming down with one of the symptoms, and in that case, then you might be able to establish the direct threat and move on from there. But I would advise to exercise caution before asking about certain types of symptoms of an employee when the sole basis for those questions is that the employee has returned from a trip to West Africa.
Okay, we have another sort of related question. This question, the employer is a healthcare provider who cares for elderly, at-risk, immunocompromised patients. Can the employer require an unpaid leave for 21 days following their return from affected areas, as noted on the CDC website, and allowing employees to use vacation or sick time? Even in this situation, and we know that this is very frustrating for employers in this situation. The problem is you still have the same analysis that you have to go through as it relates to a direct threat. So obviously, as part of that direct threat, you can consider the impact of, who your workforce is and who your patients are, that there is the direct threat to the workplace. That may be very different if it's just people sitting in an office environment in terms of what that direct threat is to the workplace, but just the fact that you're dealing, for example, with children, or you're dealing with the elderly or immunocompromised, does not, as things currently stand, I don't believe, under the way that the CDC guidance is being done, or, in those states where they have not imposed mandatory quarantines of people who are returning from certain areas, would not in and of itself necessarily provide the direct threat simply because somebody is traveling from that area. We have situations where people are being monitored by health officials, they've been screened, and where those health officials do not believe that there is a threat to the public, and given that you have to have symptoms in order to be contagious, the simple fact that somebody has traveled to those areas would not necessarily, in and of itself, based on the threat level that has been determined by public health officials, give you the ability to do that. Now, if the CDC were to issue guidance, if the state health department in your state were to issue guidance that says, public health officials cannot allow, hospitals and healthcare providers cannot allow people to work after they've traveled from certain areas or after certain types of exposures, then that would give the employer the ability to make that determination. But as it currently stands, we really don't have that situation, and I think an employer who in and of themselves makes that determination and says, we are going to force you to sit at home, somebody who is not displaying symptoms, and really it's based on nothing more than the fact that they have traveled to an area where the disease exists, that in and of itself would not provide the ability to require people to be out of the workplace. Another question that came in is, taking that scenario, what if you knew that the person was actually exposed to Ebola? In the presence, for example, of a family member who had Ebola, caring for people who had Ebola. That is a very difficult situation. We right now, under the CDC guidance, employees, and this is really particularly in the healthcare industry, if you think about, the situation of the doctor who just came back, or the nurse who was quarantined in New Jersey and then traveled to Maine, and Maine tried to impose the quarantine on her. These are people who we know were exposed to Ebola. They were treating Ebola patients, and here, even in those circumstances, we have the CDC saying there should not be a mandatory quarantine in these circumstances. There should be monitoring, and in Maine, they went so far as to trying to get a court order to impose a quarantine on this nurse, and the court wouldn't impose it because they said she doesn't have any symptoms. And, these are people who are working in the healthcare industry. So when the CDC says we don't need to quarantine all these returning healthcare workers, these are people who presumably are going back to work in hospitals, in places where there are going to be people who are certainly immunocompromised, and yet the CDC has taken the position, and not just the CDC, but if you were to, look at this issue, that CDC decision has been widely supported by the healthcare community, saying there just isn't that level of threat if people are monitoring. So just the simple fact that somebody may have been exposed to Ebola would not necessarily give rise to a direct threat, although I believe that it would give rise to your right to make additional inquiries to determine if there's a direct threat. So trying to understand, what does it mean that the person was exposed? Does that mean that they have a family member who was ill, or does that mean that they were directly caring for that family member after they had symptoms while they were in their home and without using protective equipment? Then, there may be a situation where you'd at least require monitoring. But again, remember that that 21-day quarantine period, if the person does not show any symptoms, they're still not infectious. So there's still a question about whether you could require somebody in that circumstance to be out of the workplace, and particularly in a circumstance where it's going to cause a detriment to the person. You know, some people can easily work from home, but typically in the healthcare industry, or those people who are providing direct service in immunocompromised or to children or things like that, that's not the case. You can't do that from home. So we're talking about people who are having to be out of the workplace, often without pay. And in a circumstance where state and federal health officials are aware of the exposure, are monitoring the person, and have not chosen to quarantine them, I think it's very difficult for an employer to say, I am making an independent determination that goes beyond what state and federal health officials believe is appropriate and making the determination that you're a direct threat in my workforce, even though these state and federal public health officials do not believe that it's a direct threat to have you, be riding a bus, be going on a plane, be, living in completely normal circumstances. So I think that's where you're really going to want to go through carefully those kinds of circumstances if you become aware of that potential exposure, because there is definitely a balance between the need to protect employee rights in this circumstance and also to protect the members of the public and other members of your workforce during this time. But I think, our overall guidance is going to be, deal in facts, not in fear, because we're seeing a lot of anxiety. And, I've received a lot of calls from employers saying, what should I be getting out to my workforce about this? What should I be telling people to do? And I said, I don't think this is any different than what you would tell people to do, as it relates to flu season. If you feel sick, stay home. Wash your hands, sneeze and cough into your elbow. All the basic things that we talk about disease prevention in the workplace without a more specific threat, then that's, the kinds of general guidance that we're going to be providing to employees. One other issue that we didn't talk about that comes up is suppose you have to send an employee to an affected area on business. What steps do you have to take? And there, you're going to want to make sure that obviously all proper protective equipment is being provided and that there's, health care available, that there's monitoring of that employee when they return, again, for the protection of the employee because of your duty under OSHA to protect that employee. One thing that's very interesting in this regard, so at the same time that the CDC has said that they are not going to impose a mandatory quarantine of healthcare workers who are returning from treating patients in Ebola, they're just going to have there be monitoring of these patients. The military has taken a slightly different approach where they have sent military personnel into these countries to provide facilities that are going to support additional U.S. healthcare operations to try and help combat the violence, because the virus, not the violence, some of that too, but the virus, because there's not the infrastructure in some of these countries to really help control the spread of infection. The military did take the stance that it was going to quarantine its troops traveling back, and in fact did this with the first round coming back even before they traveled back to the U.S. And when questioned about it, basically what the military commander said is, this is not people who are traveling voluntarily, and they felt it was appropriate to protect both the employees who were traveling and to be sure and really control, because they had been, these are military personnel who'd been sent over. It's not a voluntary travel to visit family. It's not a voluntary assignment, and also to protect families returning. So even within the federal government, we definitely see the tension that can arise in this. Okay, we have another question. What would be an appropriate duty to inform protocol about traveling to and from an affected area to avoid discrimination, but encourage this information to be shared? Would all traveling employees be asked to inform about the location of their travels? So this is an interesting question, and one that has come up, and I think one about which there is a, could be a potential difference of opinion. So while this is going on, while there are concerns, the question is, could you have a policy that says, all employees must inform inform us anytime they're going to travel out of the country? So, but potentially, the question is, however, as an employer, what are you going to do with that information? And what are you going to do if an employee says no? If they say it's none of your business, and that may, and the other issue is it may reveal information about national origin to which you are not otherwise entitled. You don't typically get to ask about your employee's national origin. Why do you want that information? And if it's really to get at, is there a potential exposure? Again, it goes back to this question of, is just the fact that somebody traveled to that area enough to trigger any monitoring or reporting obligations to you as the employer? So I know there is definitely guidance out there where people have suggested, yes, you can ask those questions. And I think if they're asked of everybody, there's not any specific federal or state statute that I can think of that it violates. However, beware of the law of unintended consequences, because now you've asked potentially for information that's going to reveal personal information, which could then be used against you. And in addition, you have to consider what you're going to do if people refuse. So that asking the question may not violate the law, but if you were in fact to discipline or terminate somebody because they refused to answer a personal question, then you could, you could incur certain types of situations. It could be protected concerted activity under the NLRA. There's a number of situations that it could fall foul of.
In addition, you also want to be careful that if you have employees reporting to you intended vacation destinations, that you wouldn't then be in a position where you could deny certain vacation requests to perhaps a West African country, but yet grant it to another location, because then, of course, you're opening yourself up to potential disparate treatment claims. And so, again, the law of unintended consequences, you want to just be careful the information that you ask for and really what purpose are you actually asking it for before doing it.
But the initial question about what kind of a protocol would be appropriate, there's nothing wrong with saying to employees, again, in that vein of education, to say, look, if you're traveling, first of all, you could do general guidance for air travel, because the fact is, anytime you get on a plane, anytime you travel, you're being exposed to germs. That's just the reality. You don't know where other people on the plane have been or what kind of exposures they have regardless, and we saw that, as it relates to H1N1 and other various pandemics. So there's nothing wrong with doing general guidelines for, airplane travel. In addition, there's nothing wrong with doing general guidelines or guidelines that say, look, if you're traveling to countries with increased risk of Ebola, here's some guidelines in terms of, whatever equipment people might want to take with them, like, bring rubber gloves or whatever it is. And in terms of what to expect when they return. You'll be subject to monitoring by the government for a period of, 21 days by state and local public health officials. You may want to consider whether you want to voluntarily remove yourself from the workforce during that period of time to avoid any risk of exposure to your colleagues, things like that. And even guidance about, making sure that they don't affect their family members. So it's not just about the workplace or, voluntarily perhaps limiting their movements until any of that. So there may be best practices that you could talk about, about keeping everybody safe, including family members, things that you can do, basic infection control that would be perfectly appropriate guidance to just give generally during this period of time. But it wouldn't really be very different than, when we had an H1N1 pandemic. The only difference really is that this has been more localized in terms of where we see the pandemic. But we've seen that in the past. I think this one has just gotten more public fear, at least in the U.S., and I think some of that is, you know, perhaps sort of the graphic nature of some of the symptoms. And I also think, you know, the people of a certain generation, and I'm not joking about this, I think the movie Outbreak that people of a certain generation saw, it looms large in people's memories, and that's what people sort of envision, even though the reality may be something very different. We are going to wrap up now because we are at the end of our time. We thank you for joining us, and you can feel free to reach out to any of us with additional questions. You have our contact information available on the slides. You'll receive the webinar recording and slides in a follow-up email. When you exit the program, you'll see a short survey on your screen. We'd appreciate you taking a moment to complete the survey. Your feedback is very helpful to us in planning future programs. And please keep an eye out for future Ballard in-person and webinar programs. Thank you so much.